welcome to the Farming Podcast. My name is Mbali Nwoko, and I am your host for this evening's podcast, like I always am, with the Farming Podcast. And today we're joined by Bongani Masuku once again from Cliffe, Dekker, Hofmeyr, and he's an employment expert. And today's just a continuation of certain topics that we weren't able to discuss in the previous podcast episode. And just to give you a brief rundown or summary of what we discussed in part one is that we went through the topics of the fundamental requirements or standard things that need to be in place when an employer and employee enter into a contractual agreement, and specifically one that is pertaining in terms of employees' job responsibilities and the requirements in the workplace. And also, we touched base on the foreign nationals that we find on many South African farms today, what their rights are, what an employer's legal mandate is when, what an employer's legal mandate is required when employing foreign nationals, and the things that South African farmers should do on their end to ensure that they meet with regulations and are employing individuals as per the law or the Constitution. And then lastly, we also touched based on the dismissal factor when farmers are faced in a situation where they have to dismiss employees from the workplace, and those employees maybe are living or residing within the farm's premises. You know, sometimes individuals cannot work to and cannot travel to and from farms because farms are really geographically located in very vast and diverse areas, very far from towns as well, very far from public transport. And so we discussed with Bongani in part one in terms of what happens when an employer has to dismiss an employee when they're living on the farm and those rights. So if you missed the part one episode, you could definitely catch that episode live on YouTube under the Farming Podcast playlist in the Private Property YouTube channel. So if you're watching us this evening, thank you so much for joining us in our part two of our conversation. Once again, I encourage you to like, share, comment, and ask our guests any questions that you have that need certain clarity or advice. And we will link the Bongani's details after the show, should you wish to email him and maybe discuss any legal concerns or issues that you're faced with on your farm, in your agribusiness today. But without further ado and without wasting any much more time, I just want to introduce Bongani. How are you doing, Bongani?
I'm very well. Thank you for having me, Mbali. And good evening to yourself and to the rest of the private property listeners and viewers out there. Thank you.
So I want to touch on today about two big topics, which is mostly labor unions in the workplace as well as COVID-19. I think it's very important to discuss what current matters and current issues so that we can help people navigate through any challenges they're facing during this time. But on the issue of labor unions, tell me, what's the minimum number required for employees to become part of a labor union or form a labor union within the workplace?
It's an interesting question, Mbali, and I'm glad you bring it up because the first port of call is obviously the Labor Relations Act. Section 4 of the Labor Relations Act creates a universal and general right for all employees in all workplace types, forms, and shapes across South Africa to participate in, to join, and to form a trade union organization. So that right is completely without limitation in terms of the numbers of people that are required as per to be a minimum number of people to start a trade union organization, as well as there's no minimums in relation to the number of employees that must form part of that particular trade union organization before it can be recognized as such. So there are two things here. It is the process of forming a trade union is something that is legislated and that is something that falls under the purview of the Registrar of Labor Relations, which is an office bearer in terms of the Labor Relations Act. She is the person that registers trade unions. So trade unions are registered independently of the employer party. And then after the trade unions are registered, then they can start to tout membership within an employer's business. And I can think of, for example, in the agriculture space, we have some of the largest unions being the National African Farmers Union of South Africa. And that union does not necessarily require a minimum number of membership or before it can start recruiting members. It is just an application, or it is just a byproduct of every employee having the right to form, take part in and participate in the affairs of the trade union. So the simple answer to the question is every single employee in the country, even every single employee in the agriculture and farming industry, have a right to form and participate in the affairs of a trade union. That's the simple answer to the question.
And the reason for wanting to form part of a trade union or participate in the trade union would be because employees maybe feel that they've reached a ceiling in bringing their grievances to the workplace, and therefore they'd form part of a trade union. Is that correct? Or are there other reasons that push employees to maybe seek the advice or want to be part of a trade union?
So that is correct. Mostly employees join trade unions so that they can have whatever grievances they may have at any given point in time during the currency of the employment resolved through the intervention of a third party, the trade union. So you have on the one hand the employer party, and then you have the employee party, and there may be issues that arise that are far and wide between the employer and the employees. And in some instances, those issues become a bit too complex, or they become a bit too involved to be resolved between the two parties, being the employer and the employee parties themselves. And the intervention of a third party is sometimes called for. Of course, there are other advantages to being a member of a trade union over and above just having grievances being resolved. I can think here of issues such as annual or wage negotiations, which happens over certain periods of time. And it's not just an issue that's left to the contract of employment in terms of what salary increments an employer in the agriculture industry would implement as a salary increase on any given year. It then becomes an issue for centralized bargaining between the trade union parties and the employer parties, depending on whether the employer parties are negotiating individually or if they're negotiating as part of a conglomerate of employers, loosely referred to as an employers organization. So that is the other aspect of the discussion that I need to sort of highlight for our agricultural sector. That is, it's not just the right for employees in terms of Section 4 of the LRA. Section 6 creates an equivalent right for our employer parties to actually form and participate in the affairs of what is now referred to as employers organizations. Agri-SA, I believe, provides such services to the employer parties, and it's not just to serve as an organization for employers, but does various things for its members, who are the employer parties in this instance. So yes, to resolve whatever issues and to deal with any other issue that the union, trade union organization has the competence to deal with, is something that attracts employees to joining the trade unions. But as I say, it's mostly just to deal with employer-employee related issues. It may be that sometimes when the employees get dismissed from employment, they have to refer their cases to a bargaining council or the CCMA, depending on where you fall. And the trade union organizations come in handy to assist employees with those referrals as well, because as you'll be aware, the labor relations playground in South Africa is quite a complex and highly regulated area. So it's not everybody that has the ability and the capacity to understand the rights and obligations that are created, or the additional rights and obligations, I should say, that are created by the Labor Relations Act and the Basic Conditions of Employment and all the other acts that find application in employment law in South Africa.
In farming, we always have a mix of employees, I think, as with any organization. But mostly farming work is also seasonal work. And so I just want to find out, does the right to be part of a trade union or a labor union only speak to permanent employees, or can contract or seasonal workers also be part of a trade union?
So the right does not depend on the tenure of employment, i.e. whether the person is a permanent employee versus a person who might be a temporary employee versus a person who might actually be a casual worker. It is a right that is extended to all employees as long as the person fits the description or the definition of employee. Then they have a right to form part of a trade union organization. Now, the difference is with independent contractors. The independent contractors may, if they elect, choose to form part of the trade union for whatever benefits they think they may reap from the trade union, but there's very little to be reaped by an independent contractor from a trade union organization. And the reason is simple. Independent contractors operate much like, let me use the example of plumbers. They come in, they provide a service, and they issue an invoice at the point when the project that they're working on for the benefit of the employer is completed. So they do not enjoy the rights in terms of the Labor Relations Act that employees enjoy. So it would really be superfluous, I can't find a better word for superfluous, for independent contractors to join in a trade union organization, because they don't have the rights in terms of the Labor Relations Act for example, centralized bargaining. They don't have the right to fair labor practices in relation to how they get handled in terms of suspension, for example, where they've not done a good job, they've done a shoddy job. How you handle them is in terms of the contract that you have in place between yourself as an employer and the independent contractors. So there's very little application to independent contractors for trade union membership. But certainly in terms of in relation to employees, whether they're permanent employees, temporary or casual workers, they have a universal right to join a trade union. And it doesn't matter for what period or what season they're employed for as long as they're employees, they may form part of, they may join a trade union and reap the benefits of joining such a union.
And most employers, I know, and I'm sure many that you know, the minute the employees tell them that they're going to be part of a trade union, everybody begins to become concerned. They think there'll be drama in the workplace, there'll be more issues in the workplace, there'll be less production in the workplace, and there's this whole negative stigma around labor unions. But as an employer, once employees inform them that, I'm going to be part of a trade union or a labor union, I'm still not sure which is the right term, rather. Do the employers have the right to accept or reject that the proposal from the employees to say we want to be part of a trade union or a labor union?
So the simple answer to the question is no. Once you have a trade union coming knocking on your doors as an employer, looking to recruit members, etc., you really don't have a right to tell your employees to not join the trade unions. In fact, if you tell your employees to not join the trade union, you would be infringing on their rights to join and form part of a trade union organization, right? In terms of Section 4, and you would be in some trouble with the authorities, to use that term loosely. So that right is universally enjoyed by employees and has absolutely no limitations. There are some limitations in terms of majoritarianism, because we live in a majority democratic constitutional state. There are certain rights that certain unions enjoy on the basis of what their numbers are of employees or members within a particular employer's workplace. And such rights may differ from one union to another, depending on their levels of representativity, what lawyers refer to as levels of representativity. So the simple rule here is that majority rules. So the one trade union that has as its members the majority of an employer's employees is the one that will enjoy the most rights in that workplace. And it's as simple as that. But no to the answer, to, the simple answer to the question. You may not tell your employees to join a trade union. And in fact, you may not even disadvantage them just because they form part or they have joined a particular trade union. That is something that we refer to in the labor space as trade union bashing. And that is something that is particularly frowned upon by our labor courts and labor appeal courts all the way up to the Constitutional Court.
I see. And moving on to the current global pandemic, COVID-19, right?
Yes.
We hear reports about there being some stigmatization of people, whether in the rural areas, in the township areas, where, if you have contracted COVID-19, people tend to get isolated from their neighbors, from their community members, where they reside. And so I just want to find out, since the pandemic started, have you had instances where employers have had problems with maybe trying to get the employees back into the company or into the workplace physically, obviously abiding by the COVID-19 regulations? Have you had instances where employers have struggled to get employees come back to the company even after they've contracted the COVID-19 or I suppose, recovered? That's the word I was looking for. Even if they've recovered from COVID-19, do you find that employees have a challenge with their employees, especially where stigmatization is concerned? Because I can imagine, if you've gone through such an ordeal as an individual, you'd want to get your life back in order, and I think just continue life as normal. Obviously, be grateful for this opportunity to have gone through this horrendous experience, as many people have shared how painful the disease has been to them. So maybe just share some stories or anything relating to stigmatization within the workplace from employees, and how employers have had to deal with this issue.
So in terms of the government's regulations and the directives on COVID-19, all of which arise from, obviously, the Disaster Management Act, every employer is expected to operate as close to normal as possible while making sure that they comply with all of those regulations and directives in relation to health and safety, and maintaining a level of safety within the workplace in relation to the spread of COVID-19. Now, when I say operate as closely as normal, I don't mean in the sense that, it's business as usual. It's definitely not business as usual. I mean, you as an employer party are expected to create an environment so conducive to business operations that you are able to run your production to the level that is achievable while maintaining the necessary social distancing requirements and while ensuring that everybody is kitted up with the necessary PPE to protect themselves from infection, right? So the stigmatization of employees is quite a reality, not just in the agriculture sector, but in other more informal sectors as well. And I think it's a byproduct more than anything of just a lack of information by our people, unfortunately. And I would suggest that employers, particularly in the agricultural space, where employees are mostly your blue-collar workers, and it's not employees in professional services, for example, who have a relatively high level of understanding of these things, including the regulatory framework that is applicable, I would highly, highly recommend that employers go on an information drive where they disseminate as much information to their employees as is possible about the virus itself, how it spreads, and about how the virus is not necessarily a death sentence for anybody. We've experienced this in the mining industry back in the days when silicosis came up, and anybody who contracted that disease was kind of sort of shunned and looked upon as if, they were a leper, as it were. And we have come a long way, I think, in defeating that stigma against a disease such as silicosis. We've even come a long way in defeating the stigma against HIV and AIDS through the sharing of information, through information seminars, webinars, etc., whatever it is. Sometimes it takes just a morning meeting, general staff meeting, where management or members of management speak to employees about the disease, where it comes from, what it means, and the fact that it doesn't actually necessarily mean a death sentence for a person who has been infected by the disease and survived it. Those people are still the same people that they were before they contracted the disease and beat it, and they should remain so in our eyes. And that is effectively the drive that I would recommend for employers in the farming industry, because that's effectively what it is. It's just another disease that anybody can actually get, subject to what they interact with or who they interact with and how they interact with those persons. You can get infected from absolutely really anything, from a touch of the surface. It's as simple as so anybody can get it, and there is absolutely no reason. This is something that needs to be drummed down to our people. There's absolutely no reason for stigmatization in that regard. In relation to the second part of your question, I can attest to examples where employers have seen either an unwillingness by employees to return to work because of fear of contracting the virus, and other employees being loath to come back to work because they have either contracted the virus and beaten it, or they have to observe what has now come to be a 10-day quarantine period. And I think it's quite important that employers understand the applicable legal framework in that regard. And the long and short of what you as an employer have an obligation to do is to ensure the health and safety of your employees. That obligation comes from the Occupational Health and Safety Act, and that's an act of general application. It applies in the farming industry and the agricultural industry as well. Section 8 of that act says you as an employer have an obligation to create a safe working environment and maintain a safe working environment for all employees and for all persons that come into contact with your workplace. And that gives rise to certain obligations, including, for example, considering to what extent you need to reconfigure your farming operation such that you are part and parcel of the fight against the spread of the COVID-19. This entails, in some instances, depending on the nature of the workplace or the business operation that you run, it entails looking at a floor plan, determining how many square meters your farm operation or business operation spreads, and determining if 1.5 meters between persons is achievable at all times if you keep all of your employees coming back to work. And if that becomes an issue, then you need to think about, well, maybe we might need to reduce our operating capacity. If you operate a large farm that, say, for example, has up to about 1,000 employees all at once, then you might have to scale it down to a number that meets the floor plan so that you are able to maintain a distance of 1.5 meters between persons at all times. And then, of course, comes in the issue of usage of gloves, usage of masks, usage of sanitizers and things like that as being sort of the minimum requirements in terms of the regulations and directives from government. So when it comes to COVID-19 in the workplace, the obligation is simple. You need to create and maintain a safe working environment for all your employees, which means you need to comply with all of the regulations in relation to space, how many people are in the workplace, how to what extent people come into contact while in the workplace, and what PPE they have access to be able to use to protect themselves against the spread of the virus. If you have done that, and if you are able to run and operate a business operation that runs almost to full capacity with all of those parameters being in place, then you should be fine. You should be home and dry. It may be, through unfortunate events that you then find yourself having infections in the workplace. But once infections do happen in the workplace and are picked up, somebody tests positive. We even have an app now that traces the number of people that have tested positive for COVID-19. You can implement that as part of the requirements in your workplace. But once you have control of who is doing what and who is infected and who is not in your workplace, then you can sort of try and return to as far as possible, a normal business operation as you possibly can achieve under those circumstances. But as for the stigma, I think it's just a question of information dissemination by employers to employees so that everybody understands. And where it becomes a bit more difficult, with employees being a bit recalcitrant and things like that, then you have recourse to disciplinary action for those that are doing something wrong within the workplace. We've seen instances where the CCMA has dealt with cases where employees have wanted to stay away from work, even though the employer has declared the workplace to be safe to return to work for its staff complement. And that is something that is within the powers of the employer if an employee or some employees or group of employees become difficult about coming back to work or coming into contact with a certain person who may or may not have tested positive and have now beaten the virus. Then you can resort to disciplinary action in relation to those issues. But really, it's an information dissemination drive that will kill the stigma, is my view.
As you're also talking, I'm thinking, fortunately in my organization, I haven't had any positive cases. And I'm just thinking for some employers who are faced with the dilemma where employees have contracted the virus and they have exhausted their leave days. How does this work from a contractual agreement? I understand maybe the normal human reasoning will have to come into play with this because we are in a pandemic. And especially for those employees that have contracted the virus and the virus has really taken a severe toll on their body, that have actual symptoms and really cannot work. So how do we manage that whole point of discussion in terms of now, does this form part of sick leave? Do we have to extend sick leave? How would it work in this instance?
So it's quite an important question. The contract of employment provides, amongst other things, we spoke last week about the particulars of employment that must be put in writing for the benefit of the employee. The contract of employment will provide one of those particulars is the number of leave days that an employee would be entitled to over a financial year cycle. It also entails telling the employees in those particulars about the number of sick days or sick leave days that they would be entitled to over a 36 months sick leave cycle, because that's what the basic conditions of employment refers to it. The answer to the question about what happens when an employee either tests positive for COVID-19 or fears that they've probably contracted the virus, even though they may not have tested, is the following. When an employee has not tested positive for the virus and does not necessarily have symptoms of the virus, but feels that they may have been exposed, there is an absolute obligation on the employer to ensure that that employee does not come into contact with other employees within the workplace, which means that the employee must remain at home at all, for all intents and purposes. Now, the second part of the discussion becomes, well, what kind of leave do you give to an employee that is in that position? Remember, it's somebody who's not sick and who's not tested positive for the virus, but who feels that they may or may not have been exposed. So you can resort to normal annual leave insofar as the person has leave days available for the number of days that they require to be in quarantine out of the fear that they have of having come into contact with the virus or somebody who's tested positive with the virus. That's the first option. The other options are if the employee is not just suspecting that they've come into contact, that they have actually tested positive or are actually symptomatic. They show some symptoms, loss of taste, loss of smell, cough here and there, struggling to breathe, the typical symptoms for the virus. Then that person actually falls into the category of sick people because they've tested positive for a global pandemic, for a global virus, right? And so it's no longer annual leave for that person because it's not just a suspicion and a precaution by just quarantining. It's actually a positive test and some symptoms. So then you resort to sick leave for those persons. Now, the third part of the discussion is what happens if the person has exhausted either their annual leave or their sick leave or both. Then you have to start thinking along the lines of, in both instances, unpaid leave, because the obligation on you as an employer is to absolutely prevent any whisker of suspicion of somebody being positive for the COVID-19 in your workplace, just because of the risk that it brings to the rest of the staff complement that you might have in your workplace. So if it's a suspicion, then you can give the person annual leave if they have days. If they don't have days, then you may have to resort to unpaid annual leave. If it's not a suspicion, but an actual positive test and some symptoms, or one of the two, then the person falls into the sick leave category and you have to give them their sick leave. If they've exhausted their sick leave, then you also may have to look at unpaid leave. With the advent of what we are on now, which is the adjusted level 3 since the 28th of December 2020, we have started to see, and the developments now in the policy and regulatory framework the President has spoken about, and the Minister of Occupational, we are in the space of a third type of or category of leave that is being introduced, which is called COVID leave, where people can be entitled to claim from the UI fund for those days of those number of days that they have to be out of work because of being in quarantine or because of trying to recover from COVID-19. But that's a new development, and subject to just checking the detail from the regulations in this regard, that has either immediately come into effect or that is yet to come into effect. But you're looking at the leave situation there, and that's basically how you'd have to deal with it as an employer. But keep in mind, you cannot allow such a person to come who either suspects they've come into contact with somebody who's positive, or who actually is symptomatic, or who has actually had a positive test result to come into contact with the workplace or any other person within the workplace. They must quarantine for the requisite 10 days until they've got a negative test, and then they return to work.
All right. And so lastly, on the vaccination point, is it an absolute must for employers to take their employees to get vaccinated, especially in sectors that are essential service sectors where, you know, the demand, the need for employees to be at work is extremely crucial. So how does it work where vaccination is concerned? Should employers vaccinate employees for the in-demand sectors, or can employees have the option to say, I don't want to get vaccinated, and therefore, you know, I'll still come to work, you know, still maintain the necessary protocols with regards to the regulations, but can employees also still have that obligation to say no to the vaccination? And could it also maybe work the other way around, where employers are still pretty much laid back on this vaccination idea, and employees can then force or put on pressure from their employers to get themselves vaccinated? How does it work when it comes to the discussion around vaccinations in the workplace?
All right. So the most important viewpoint to take is the first citizens' viewpoint, and the President has said that vaccination in South Africa will be on a voluntary basis, right? And that is the government's stance. However, that does not mean that for an employer in essential services who has a flurry of employees in their business operations, and in respect of whom it's really difficult and in some instances near impossible to keep these people from interacting with each other and coming into physical contact with each other, it's still an option for that employer to consider compulsory vaccination for its workplace. And it really depends from one employer to the next. The rights at play here are some constitutional rights as well as some statutory rights that employees enjoy, including, in fact, not just rights, but actually lifestyle preferences and interests that some employees might have, which may go against them taking the vaccine. So, for example, from the Constitution, everybody has the right to physical autonomy. Physical autonomy meaning that you have a right to determine what happens with your own physical body. Yeah. So the issue of taking the vaccine would touch on that right. So an employee, from a constitutional law point of view, can say, no, I'm exercising my constitutional right, you may not vaccinate my body. And that is a right that the employee has. From a statutory point of view, the National Health Act provides that any medical procedure to be conducted performed on any person must be done so with the informed consent of that person. So a person must give their informed consent for any medical procedure, including vaccination in this case, right? And then the Employment Equity Act, Section 7, speaks about medical testing in the workplace, and again says it may not be done unless it is job specific and unless it is done with the consent of the employee or required by a law, right? And in relation to whether or not an employer in the agricultural industry in South Africa must consider mandatory vaccination for its business operations or not, the answer is it depends. It depends on the nature of the workplace. It depends on how effective the current measures that we have in place already in an attempt to combat the spread of COVID-19, how effective those are. If they are not effective, then a vaccination or compulsory vaccination for your workplace business operations might be a very important tool, might be an important weapon to ensure that you are at least able to run your business operations to full capacity while complying with your obligation to create and maintain a safe working environment for all employees, right? So the answer to the question is really it depends. Other factors that you might want to take into account are exactly how much physical contact does your business operation dictate for the persons that work within the business operations. If there's minimal physical contact, if the measures that you've put in place, like giving out gloves, if you give out gloves, giving out masks, ensuring that there's sanitizers at every single office and at all entrances and common areas, including the canteens and things like that, and ensuring that people remain within 1.5 meters of each other. If that is working and it's working well and it's effective, and you've not seen a rise in infections within your workplace while applying those measures, then you would probably be able to get away with not having to look at mandatory vaccination. But if the converse is true for your business operations, and if you happen to be an essential service, where you cannot just stop operations and put your tools down, then the discussion of mandatory vaccination might come in handy for you. And here, for the more informal employers, so for the more smaller smaller farming operations, you might find that a simple talking to from management to employees and request that they give their informed consent. And informed consent means something here is very specific in Bali. Informed consent means that you need to inform the person of really the full extent of what it is or what it means to be vaccinated, what will happen, how it will happen, why it will happen, and what are the expected consequences for vaccination once vaccination is done. Informed consent also means telling them exactly about their rights to say no to vaccination if they choose to not take the vaccination with reasons, and what the consequences would be or might be for those persons who choose not to be vaccinated. So for the more informal guys or the more informal employers within the agri sector, you might find that a simple conversation from management to employees and a request, and then you would have to probably get them to fill consent forms to being vaccinated, and you insert those into their personnel files, might suffice. But for the more sophisticated farming operations, farming business operations that have a number of staff and a number of business operations that come into play, where things become a little bit more complicated and a more corporate environment is required, then you would need to probably introduce a mandatory vaccination policy. And again, the choice of going with a mandatory vaccination policy or not depends on the circumstances applicable on the ground in the workplace business operations themselves.
Oh, Bongani, geez, you've said a mouthful, and it's quite detailed, everything that you've explained. I personally have to even go back to this video and obviously take some very key points that you've mentioned. And I think it's critical for both employers and employees to understand the current legislation when it comes to vaccinations and anything and everything that has to do with the global pandemic, because it's going to be here for some time and we need to find ways to work around it and still have business as usual. And a lot of people right now are desperately need for income, are desperately need to remain in their workplaces, to have a job, because it's been a very, very traumatic year for many people, whether people were infected by COVID or not. But, we don't live in isolation. We live with families, with communities. And trust me, I think by now there must be someone, everybody must know someone who has been directly affected by COVID. And so,
absolutely.
It's important to continue to look forward to the future, but also basically taking care of ourselves. So all these points that you've mentioned have not fallen on deaf ears, and I definitely, as an employer myself, have to take notes. But thank you so much for sharing your insights in a very, you were able to explain very complex situations that exist in the workplace in a way that I think the average Joe can understand. So thank you for breaking it down in quite detail in the manner that you have, because I guess for even some people, such discussions and things that we spoke about tonight are quite personal to them. So thank you so much for your time this evening. I know we've extended the podcast a little bit, but thank you so much for your time. And I know you're in the office and working hard, but really we appreciate your expertise and insights.
No, thank you very much. Thank you for having me on the show. I do think that for some specific employers, the vaccine might be a very powerful tool that enables them to keep everybody in employment, avoid retrenchment, run your business business operations to full capacity. But having said that, thank you very much. Thank you for having me on the show.
It's a pleasure. That was Bongani Masuku, the director of Cliffe Dekker Hofmeyr in employment law. And today we discussed everything to do with labor unions as well as the global pandemic, what employers need to do with employees in the workplace where vaccination is concerned, the stigmatization of COVID-19. And we also talked about the labor unions, the rights that employees have when it comes to joining or forming part of labor parties or labor unions, and similarly with employers. And so if you missed this evening's live, you can catch it once again on the Private Property YouTube channel under the Farming Podcast playlist. This is where all the videos reside. And I will be joining you once again on Thursday. And please make sure to also watch all our other podcasts that we have during the week. And if you miss any of our shows, again, please visit our YouTube channel and continue to interact and engage with us and ask our guest questions, even though the live has ended. So on YouTube, you can ask questions and we'll do our best to answer and make sure that you are constantly kept informed. So for me, this is good night, and I will see you on Thursday.